Okay, so it has been a long time, 3, 4 months since I've recorded one of these lectures. So the Constitution test. Here's the deal. Here at Carmel, it's 50 multiple choice questions, and you can't get around reading the Constitution. You got to read it from start to finish. This lecture will do a good job. It'll answer probably 45 out of those 50 questions. But if you want a perfect score, if you want an A, you need to read the Constitution because I have buried a few questions in the test that you can only get from the text itself. And it's not difficult stuff, and it's not meant to trick you. But I really want you to read the document. It's let's be honest, it's the most important document in our country. So deal with it. All right, so the Constitution that we have today is not the first Constitution. It's Constitution 2.0. Our first Constitution was the Articles of Confederation, which were created during the Revolutionary War. And there were many, many problems with the Articles that you read about in Chapter 9. One of the biggest ones is there was no executive branch or judicial branch. There was only a legislative branch. And when you have this type of situation, you have a body that can pass laws, so they create laws, but they don't really interpret it and they don't enforce the laws. And you can't really have a Congress in this case force the states to do anything. The states had too much power in this relationship. It's a confederal type of government, very, very rare, and they never work. And as far as collection of money, like tariffs and taxes, they were left up to the states themselves. So you might have a state like New York, which would have a very low tariff on foreign imports, and a state like Georgia, which would have a very high tariff on imports. And so it's a disincentive for a foreign commercial producer to ship goods to Georgia as opposed to New York. And so you're having these states that start to compete with each other, not only over tariffs and taxes, but also over the boundary disputes. They each had their own currency, so there were Massachusetts bucks, and Maryland wouldn't take them, and all this other stuff. So this is not the way to have a unified country, especially one that's still in its infancy. Let's be honest here, America could have failed and should have failed probably a dozen times in its first several years, and in large part that's because of how inefficient and flawed the Articles of Confederation were. I talked about before about boundary disputes. All of these states basically claimed massive amounts of western lands, not only across the Appalachians into the Ohio River Valley, but sometimes all the way to the Pacific, and they had no clue where the Pacific even was. So the delegates meet in May 1787. Each state sends a bunch of guys, and the goal was to fix the articles, not to throw them out. But the types of guys that went there wanted to start new. They wanted a strong federal government, central government. And so right away, they basically scrapped the articles and decided to start over. The ironic thing is probably the two most important founding fathers, Thomas Jefferson and John Adams, weren't even part of the process. They were in Europe. They were the ambassadors to England and France during this time period. So, but the delegates that did meet, and the biggest one was probably Madison, they all agreed that they needed a stronger federal government, and following Montesquieu's writings, they needed to split this federal government into three branches: judicial, judicial, executive, and legislative. And nowadays we call them three separate and equal branches. But back then they still didn't want the three branches to be equal. They still wanted the legislature to be the most important branch, and you're going to see that in the document. So he had these, two major disputes, really. The first one was between large states and small states, and the second one involved the issue of slavery. Larger states like Virginia wanted the composition of the legislature to reflect the power of the more populous states. So in other words, more populous states would have more power in the legislature. And the way you do that is through census. You say, all right, X number of representatives depending on your population, and other states that have more population are going to have more representatives, and other states that have less population are going to have less representatives. If you were a small state like Delaware or Rhode Island, you hate this. And what you want is you want to have every state to be equal, whether it be 1 vote apiece, 2 vote apiece, 5 votes apiece. It doesn't really matter as long as you're on an even playing field with the big boys. So this brings us to the Great Compromise, where our legislature is bicameral, meaning it has 2 entities within it. And the lower house is considered to be the House of Representatives, and that's proportional based on population. So that's the large state plan exists in the House of Representatives. The upper house, or the Senate, is equal. Each state gets 2. And if you're wondering about the nomenclature in the House of Representatives, the people who work there are called representatives, and in the Senate they're called senators. The other major dispute was slavery, and the southern states wanted to retain it, and the northern states wanted to abolish it. Pretty much from about 1750 to this time period, slavery had died out in the North. There was a couple states where it was still legal, but there were almost no slaves left, or there were gradual emancipation laws whereby any new African Americans were born free, and after X number of years, the existing slaves would be free, and all this other stuff. And it just wasn't economically viable at all in the North, and it wasn't in great numbers anyway. The South was also dying out. It was more expensive, really, to grow tobacco using slave labor than it was even the money that you'd pull in profit. You wouldn't get a profit, and so most of the founding fathers, even the large slave owners like Thomas Jefferson, they felt that slavery was slowly ending as well, and they figured that within 20 years it really wouldn't be an issue anymore, and slavery would end. What they couldn't come up with, and why they were unwilling to get rid of it at the time, is so much of Southern wealth, instead of investing it in factories or other economic endeavors like banking or merchants like they did in the North, they invested it into flesh, into slaves. And so they couldn't come up with a way for Southern slave owners to be compensated for their investment. And if they could have, I think they probably would have abolished slavery right then and there. But they figured it wouldn't be an issue anyway within a decade or two, and so they punted. They punted to the next generation, and they said that, well, you cannot abolish the slave trade until 1807. Now, the unfortunate thing is, in the interim, in the 1790s, Eli Whitney invents the cotton gin, which reinvigorates slavery in the South. It makes the growing of cotton extremely profitable. Another one of the disputes that happens is, how do we actually vote for this new executive that we're calling a president? You got to remember, the founding fathers did not believe in democracy at all. Right? Democracy is a very negative term back then. They believed in a republic. And a republic is whereby a certain group of citizens actually votes for members of the government, and then those members of the government actually vote for the more superior members of the government and make those decisions. And so they were very worried about a king, and even more worried about a king that was kind of put in place by the people, right, the lower classes. So they created a bunch of insulating levels, and that's the Electoral College. Right? So the Electoral College originally was voted on by the state legislatures, and then the Electoral College would vote for the president. So you can see they're basically 2 steps removed from the people. And remember, the people wasn't even all the people, right? It was, you had to be white, you had to be male, and you had to be a landowner or property owner of some threshold, and that varied by state to state. But basically, you had to be a rich white guy. All right. So after the delegates vote on the Constitution and they go back to their states to pitch it to their state legislatures, there are a lot of states that were right away on board and voted for it, and a lot of states that didn't want the Constitution, were happy with the Articles. And so you get a series of essays, some written by Alexander Hamilton, John Jay, and this one written by James Madison, that collectively are known as the Federalist Papers. And they're basically commercials for, so the like political ads, political op-ed pieces, really, to be printed in various newspapers around the country to try and promote this new constitution. And the most famous one, and the most important one, and the one that you're tested on, is Federalist number 10, and it deals with factions. And it says that factions are bad. They're something that is a flaw of human nature. It's created by different types of wealth, different interests, special interests, almost always economic, and these special interests kind of group together into a club, right, or a cabal, and they control the local politics. Right? Think about here in Chicago, the Democratic machine controls Chicago. There will, well, I shouldn't say never, but in the foreseeable future, probably long after I'm dead, there will never be a Republican mayor of Chicago. The Democratic machine controls it, right? There's too many union workers and there's too many Democrats, right, in Chicago. That was the case on the local level, and it is the case on the local level around the country and in the states, right? So the state governments of places like Virginia in the South and the Carolinas, they were controlled by the large slave-owning plantation interests, right? The guys like Jefferson, Washington, Madison, those guys. Meanwhile, in the Massachusetts area, they're controlled by the merchant class, right? The John Hancock, the Adams, those guys. And in New York, you get the banking class, the financiers, the Alexander Hamilton types. So you have these different states, which are each controlled by their own economic mobs, I guess you could call them. And if you're not part of that mob, but you live in that state, then you really have no say in the government and you'll never get your interests promoted. In fact, they can be downtrodden. So there was this worry among the Anti-Federalists that one of these factions would come to control the entire country. And James Madison, Federalist number 10, says that it's just not going to happen. And the reason why that happen is that there's just too many factions. It's too large of a geography, and that if you add the number of factions to a larger geography, then one can't get all powerful, because if one starts to get more powerful in relation to the others, then the others are going to team up and destroy or weaken the most powerful one. So, and he basically said there's just way too many different interests. You can't grow tobacco or cotton up north, so the plantation owners, they're just not going to have any type of influence up north. Stuff like that. All right, that brings us to the preamble. All the preamble is, and you can see it right here, right? It's a very small portion, and this is a copy of the Constitution itself. The entire Constitution fits on one piece of paper, including the signature page. Now, it's a big ass piece of paper, but you get the idea. It's far shorter than any other constitution in the world, kind of with the exception of Great Britain, but that's only because Great Britain doesn't even have a constitution. But I digress. The preamble, the thing that you probably memorized as a little kid, right? We the people, in order for a more perfect union, blah blah blah. All that is a commercial, right? The founders knew that this would be printed and distributed in pamphlet form into newspapers across the country, and they knew that you had to hook potential voters right away. So the first few sentences there, all it is you're appealing to the common man for support, a commercial to vote for ratification. And really nothing in that preamble has any weight. Whereas the rest of the Constitution is the supreme law of the land, the preamble really is nothing but flowery language to try and get your interest. Okay, Article 1. And if you looked at that Constitution on the previous page, you saw that almost half of the Constitution, almost the entire left-hand portion of that page, is Article 1. And Article 1 deals with the legislative branch. The reason being is even though the problems of the Articles of Confederation was it just had a legislative branch and it had other deficiencies. The founding fathers for Constitution 2.0 wanted the legislative branch to be by far the most powerful branch in the government. Here we go. House of Representatives. In order to have the House of Representatives and the Senate look different, they each have to have different sections in the Constitution. They have to have different rules and regulations. And it's kind of a common test question is the comparison contrast between these two bodies. So in the House of Representatives, representatives are chosen every 2 years by popular election. So currently there are 435 members of the House of Representatives, and every single one of them is up for re-election in November every even year. So it's 2014 right now. It's the very end of September. So each and every member of the House is up for re-election in a little over a month from now. The number of representatives a state gets is based on population. This is the large state plan. And originally in the Constitution, you had this set up where the South, of course, wanted to maximize their number of representatives. And so they wanted to include their slaves in the population totals. And the North said, well, that's BS. If you want your slaves to count in the census, then you should free them. And the South said, whoa, that's nonsense. That's crazy talk. And so they almost, didn't come to an agreement at all. And so, like any other group of lawyers, they wind up negotiating, and they come up with the 3/5 clause, where for census purposes, for calculating the number of representatives a state will get in relation to the rest of the states in the country, 3/5 of, well, I should say a slave counts as 3/5 as one person. It's a pretty shady move. Impeachment power. All right. The House of Representatives is the only body that can impeach a member of the federal government. And really, we're talking about the president, right? That's the one that always pops up on the test. So when you hear impeachment, it's not the Senate that impeaches, it's the House of Representatives. We've had 2 presidents in our nation's history that have been impeached. The first one is Andrew Johnson, who came to the presidency after the assassination of Abraham Lincoln. And the second was Bill Clinton in the 1990s for a little bit of shenanigans in the Oval Office with Monica Lewinsky. All tax bills must originate here. Right? So anytime the government passes a law or starts a law that is going to raise revenue by taxation of whether it be corporations, a foreign country in the form of a tariff, or the American population, it has to at least start in the House of Representatives. And the reason being is that the House of Representatives is closer to the people because the people themselves right away got to vote for the representatives, and there can be a large amount of turnover every 2 years with those elections. And so they wanted any type of bill that's going to take money from the people, that the people should have the most say over that bill. And you kind of get that feeling even with the Tea Party doesn't exist in 2009, and then it's of supreme importance really in 2010, and to a certain degree since then. And really that's because of the Obamacare, right, which you could kind of view as a big tax bill. It just creates this fever among cranky old people around the nation that they vote in all these Tea Partiers. All right, switching to the Senate. Composed of 2 senators from each state. So this is the small state plan, even Steven for everybody. They were originally chosen by the state legislators, now by popular election. Unlike the House, which everybody is up for election every 2 years in their 2-year terms, the Senate, they operate in 6-year terms, and they're staggered. So, I just told you that this is the end of September 2014. The only the low 30s, could be 33, 34 Senate seats are up for re-election a month from now. And then 2 years from now, another 33 are up. And then 2 years from then, another 33 are up. So It's a way of slowing down the political process on purpose, of removing the Senate from the people to a certain extent, so that these passions that the people have, that if they really want this single issue, or they're really angry about something, that they can't really take over both houses, or both parts of the legislature, that you're going to have all of these senators, really 2/3 of the Senate from several years ago. They're just kind of sticking around and perhaps will vote against the bill and stuff like that. The Vice President of the United States really has two jobs. The first one is to wait for the president to die, and the second one is to be the president of the Senate. So he sits up there in the front, and he kind of is the referee in the Senate. And if there's ever a tie vote, which is extremely rare, then he can cast the tie-breaking vote. Other than that, the Vice President has absolutely nothing to do. Whereas the House of Representatives impeaches people, the Senate, it holds the trial. They try the impeachment. And it looks like a court. And for the president, that the Chief Justice is actually the judge. And the senators act as the jurors, basically. And it requires a 2/3 vote in order to convict. So just because you're impeached doesn't mean you're kicked out of office. You have to then go to the next step, which is conviction. And I already told you that Andrew Johnson and Bill Clinton were impeached. Neither one of them was convicted. They both narrowly escaped conviction by a few votes. All right, now these are powers that are common to both of the houses. Again, it's the magic 2/3 fraction. When in doubt on the Constitution test and it asks you what fraction is required, I would go with 2/3 if you don't know. The House and the Senate, they can kick out any of their members by a 2/3 vote, which is convenient if all of a sudden this just raging lunatic is voted into office. Now, by majority vote, and I'm kind of oversimplifying a little bit, if either the House or the Senate passes a bill by a majority vote, then it's going to go to the other body. And then if it passes by a majority vote there, then it goes to the president's desk. If the president signs it, it becomes a law. He also has the choice where he can veto it and deny the law. If Congress still wants it to become a law, then each house has to vote for that bill by 2/3 now, so it's not a simple majority. And if each house votes for 2/3 for that bill, then it doesn't go to the president, it becomes a law despite the president. So you can see that the president has a check on Congress, so he can control the legislative process to a certain extent, but he doesn't have total control over it because there's always a way around it. And that's really, it is one of the nice things about our government, is that each branch can check each of the other branches, but there's always kind of an escape route where that branch can, if they gather up enough power, enough forces, that they can then circumvent the check by the other branch. Congress also has the power to lay and collect taxes, we already kind of talked about, to pay for the debts of the federal government, to provide for the common defense, which is, we're talking about the military, and for the general welfare. And so what we mean by general welfare is to kind of run the country so that the citizens are happy. The Congress also has the power to borrow money. And this becomes very important with the Federal Reserve, which they create in the early 1900s, I think 1915 or so. And this is how the federal government currently is able to operate, right? Because it doesn't operate in the black, it operates in the red. So it is the borrow and spend government for the last several decades. Congress also has the power to regulate commerce. Now, if you combine the welfare clause and the commerce clause here, the regulation of commerce, this is Article 1, Section 8 stuff, then Congress can basically pass just about any law it wants to. If it wants to change the speed limit of the expressways, it can say that that's because it's trying to decrease the the high gas mileage or the low gas mileage at high rates of speed, which will increase our gas supply, which will put more money in the pockets of shippers and ordinary Americans. And because there's more money floating around, that they'll have more money to buy stuff, and they'll buy stuff not just in their own state, but in states around the country. So boom, it's commerce, right? So you can see they kind of they'll make whatever argument they want to pass a law, and then they'll claim that it's valid under the Commerce Clause or the General Welfare Clause that they can do that. Congress has the sole power, is the sole entity that can coin money, so they're the ones that decide, who goes on the quarter and if there is a quarter and stuff like that. Copyrights and patents. So these are temporary monopolies that an inventor or an author has over his work, and then he can profit by it, and it's an incentive for authors and scientists and inventors to create stuff because they're the only ones that can profit for a limited amount of time. For patents, I believe that currently you get 20 years monopoly, and for copyrights, it's several decades after your death. So even your family members get to profit from it for a long, long time. A weird power of Congress that I always thought was odd was the judicial branch really is comprised just of the Supreme Court, one single group of 9 individuals, and all of the lower courts are actually created by law by the legislative branch. So there's the Judiciary Act of 1789 and a couple others that actually set up the lower courts, and those lower courts operate as part of the judicial branch, but in theory the legislative branch could abolish them or add to them. Congress is the only power, or is the only entity that can declare war, but then this is checked on the fact that the president can conduct war, and then after the War Powers Resolution in the 1970s, the president can basically conduct a secret war without congressional approval for about 48 hours or so, and then not so secret war without congressional approval for, I think it's 60 days. So again, there's this sharing of power and this overlapping of power that these different branches have. How can the Congress stop a president from conducting a war that lasts decades and decades and decades after it's declared it? Well, it can just turn off the spigot of the money supply. Tough to fight a war if you can't pay your soldiers and fill your tanks up with gas and stuff like that. And Congress has the power to pay for the military. All right, limits on legislative power. I guess I was a little wrong on my earlier date. You can't ban the slave trade until 1808, and in fact, even though slavery is extremely popular and profitable in 1808, the slave trade, the international slave trade, was abolished. It was still possible to purchase slaves, but you had to purchase them domestically. You cannot stop a writ of habeas corpus. That's kind of a fancy Latin term for in the law. It basically means you can't just lock somebody up and throw away the key. At some point, they deserve to hear what they're being accused of, and they have a chance for a trial. So basically what we're doing in Guantanamo Bay has been accused of denying those poor terrorists their writ of habeas corpus. A bill of attainder and ex post facto law. A bill of attainder is a specific law that targets basically a single person or a group of persons with the exclusion of the rest of the persons. So you can't just pick on somebody in Congress. An ex post facto law is a law that makes something a crime, but you cannot punish somebody for committing that crime if their act was done prior to the passage of the law, if that makes sense. So let's say, trying to think of something that's new these days. All right, so you got way too many fat kids waddling around the country, right? And so Congress passes a law that says no more Snickers for you. Right? Snickers are now illegal. But we got this fat kid named Chuck, and he has been stuffing his face with Snickers for years. The law is passed on January 1st, He eats his last Snickers on December 28th, but posts a video on the internet bragging about the Snickers and all this other stuff. And so the police arrest him on January 5th. He cannot be punished because it's an ex post facto law. The action of the cramming his giant face with Snickers was done a few days before the law was passed. Another aspect of the ex post facto law is if they pass a law that abolishes a crime or reduces the punishment, then if you are already in jail, then you get to get out of jail or your punishment reduced. So they abolished the death penalty in the mid 70s for a couple of years or so, and then they actually reinstituted it. They kind of fixed it, and so then they reinstituted the death penalty. There were guys who were on death row who then get off of death row and get life sentences in prison, and when they reinstituted the death penalty, they didn't go back onto death row. It was treated as an ex post facto type analysis. So even though they were originally on death row, they go down to life imprisonment. They didn't get to go back on death row because of the bouncing up and down of the legality of capital punishment. Okay. Limits on state power. States cannot conduct treaties with foreign entities. Okay. Only the federal government can have a treaty. So, for instance, there's a current kind of embargo ban on Cuba, right? Well, Florida, despite being 90 miles away and could probably engage in a lot of business with Cuba, they can't just have some sort of trade agreement with Cuba. Right? No taxes on imports and exports. It's not up to the states to set tariffs on stuff that's coming into the country or leaving the country. It's up to the federal government to institute a tariff on that stuff. And states cannot declare war on a foreign country, right? So if Maine starts to get greedy and feeling hemmed in by New Hampshire and Vermont, it can't just invade Canada and try and grab all of Nova Scotia or something like that. Who would want it anyway? Okay, moving on to the executive branch. Article 2. It's the second largest section of the Constitution and the second most important. The president and the vice president are elected every 4 years. So it's a good way of remembering. It's always the same year as the Summer Olympics. So the next time that we have a presidential election will be 2016. Even today, they're not really chosen by the people. They're chosen by the Electoral College. Now, originally, the Electoral College was chosen by state legislatures. Now they're actually chosen by the popular vote. But there's nothing stopping a member of the Electoral College from voting for somebody else. Okay? The requirements to be president is you have to be a natural-born citizen, meaning you have to be born in the United States or on like a military base somewhere around the world. You have to be at least 35 years old at the time of inauguration, and you have to have been a resident in the United States for the last 14 years. So you can't be born in, we'll say, Chicago, and then move to Taiwan, and then you live in Taiwan for 40 years and then run for president. That's not going to work. Commander-in-Chief of the military. Whereas Congress gets to vote to declare war, the president gets to control the decisions, the strategic decisions of war. And originally this is because everybody knew that George Washington was going to be our president, and he was really our only military guy at the time that could handle something like this. So the president is the head general, if you want to think of it that way, in the military. Now, most generals, or most presidents, are not stupid, and they leave these types of decisions to the Joint Chiefs of Staff, the leaders of the military. But in theory, right, Obama could make he could micromanage and make very strategic types of logistical decisions about where to send these tanks and aircraft carriers and all that other stuff. Usually he just listens to the advice of the Joint Chiefs of Staff and says yes or no. Whereas Congress gets to vote on treaties, to adopt them, the actual negotiation and the making and the signing of the treaty is done by the executive branch. This becomes a big problem in the aftermath of World War One, where Woodrow Wilson, in his 14 points, right, wants the League of Nations and actually signs the treaty where America founds the League of Nations, and then he comes back to America, and America didn't want to be part of the League of Nations, and so Congress never does, or I should say the Senate never does sign the League of Nations. So even though we invented the League of Nations, we were never a part of it, and it was an epic failure. The president gets to appoint basically all the major appointed members of the federal government. So guys like ambassadors, federal judges, other officials, members of the cabinet, right? When you hear Secretary of State, right, Attorney General, all those guys, the president appoints all of those. What you need to do then, though, is, and this is again a check that Congress has, is it's usually the Senate, almost always the Senate. The Senate gets to kind of approve of the presidential appointments. And a lot of times that can turn very, very contested, and where you have the minority powers at the time, the minority party, I should say, at the time, will filibuster and engage in other nefarious activities to try and block presidential appointees. So it is partisan politics and gridlock at its finest. The president is obligated to give the State of the Union address to both houses of Congress once a year. It used to be because you had congressmen and the president all over the country, and there wasn't such things as cell phones or computers or the internet or TV or radio, and so at some point during the year, the president and Congress had to meet to talk about what's going on in the country. Nowadays, it's just a very large political commercial that the president, even though he's speaking in front of Congress, in reality he's speaking to the American public, and he just talks about all of the wonderful things that he did last year and all of the even more wonderful things he's going to do this year. And the members of his party stand and clap dozens of times, and the members of the opposition party sit there and scowl at him in silence. Happens regardless of the parties. The president also has the power to convene both houses. Congress goes on vacation more often than students and teachers. They very rarely, it seems, are actually doing any work in Washington. Most of the time, they're chilling in their district, shilling for votes or campaign donations. But if that's the case, and there's a world event that needs them to come back to Washington, the president has the power to drag them back to Washington. This was kind of the case at the start of the Civil War, where Congress was on recess, and they were asking Lincoln to convene Congress, but Lincoln was no dummy, and he knew that would just create red tape, so he told Congress to stay home until their appointed day, and he was able to conduct the war without them in the interim. Article 3, we're moving on. The judicial branch. Remember what I told you, there's really only one court in it, and that is the Supreme Court. There are 9 members of the Supreme Court, and it can hear a case in 2 different ways, under its original jurisdiction powers or its appellate jurisdiction powers. Under original jurisdiction, it will hear all cases involving high public officials like ambassadors, vice presidents, presidents, guys like that, members of Congress, or where the state is a party. So if Illinois sues Indiana, it's not going to go, well, it potentially could not go to a state court or a lower federal court. It could go right to the Supreme Court. And the reason being is the lower courts, especially Illinois and Indiana, would be biased in favor of the home team. But the Supreme Court hears almost all of its cases through appellate jurisdiction, whereby a case will start off at a federal district court. Somebody doesn't like that verdict, so they appeal it to the circuit court. Somebody doesn't like that decision, so they appeal it to the Supreme Court. The Supreme Court hears approximately 100 to 150 cases per year. However, several thousand, I think it's currently between 5,000 and 8,000 cases, are appealed to the Supreme Court each year. So almost none of the cases that are appealed to the Supreme Court are actually heard by the Supreme Court. Under something called the Rule of 4, if 4 Supreme Court justices want to hear the case, then they'll hear it. But the type of cases that they're hearing are usually involve new laws that really haven't been examined by the Supreme Court in the past, constitutional issues that for some reason haven't been heard in the past, or if there's a split where some of the circuit courts in the country decide this issue one way and some circuits decide it another way, then oftentimes the Supreme Court will step in eventually and say what the final answer is. All right, the states. Article 4, very, very small. Citizens of each state are entitled to the privileges and immunities of all states. Okay. Extradition. States must have a republican form of government. All right, I used to have a joke there from a member of the class, but since this is on the internet, I can't really pick on one student. But here's what I mean by that you're entitled to the privileges and immunities of all states. So same-sex marriage, right? It's a very kind of debated topic. The debate seems to be almost done, but there are a few states where same-sex marriage is not allowed still, right? Most states, I think, have gone the other way. But let's say Illinois, same-sex marriage is legal, and I believe Wisconsin, it is not. So here's how you can get around it if you're a cheesehead that wants to marry another dude. You get married in Illinois, you file all the fees, right? You do all the paperwork. So technically you're married in Illinois, and then you and your dude husband can move up north to Wisconsin, and they have to honor that marriage because you're entitled to the privileges and immunities of all states. Extradition, right? If you commit a crime, you can't flee to Minnesota, because Minnesota will be obligated to ship your ass back to wherever you committed the crime. And states must have a republican form of government. So, the governor of Texas can't just declare himself cowboy dictator for life. All right, Articles 5 and 6, moving very quickly here. Article 5 talks about how to amend the Constitution. Again, you get our magic fraction, 2/3. You'd have to have 2/3 vote by both houses, or 2/3 vote by state conventions, which really has never happened. It only happens the first route, the 2/3 of both houses. And then after that issue, we'll say it's the burning of the flag, because that seems to come up every once in a while. If 2/3 of the senators want to pass a law that says flag burning is illegal and should be unconstitutional, 2/3 of the House does, then it goes to the states. And if 3/4 of the states approve of that amendment bill, then it becomes part of the Constitution. Currently, we got 27 amendments, so that would become the 28th Amendment. Article 6 deals with debt, supremacy, and oaths. Basically, just says it's the supremacy clause, which says the Constitution is the supreme law of the land. So neither Congress, the President, or the Supreme Court can do anything really to violate the Constitution. If you don't like the Constitution, there's only one way to change it, and that's to amend it. But you can't pass any law, conduct any action, or have any court case that will overrule the Constitution, because the Constitution is king. Basically, every member of the federal government has to swear an oath upon entering office, whereby they say that the Constitution is king, and they swear to uphold its laws. All right. Now moving on to the Bill of Rights. Remember, the Anti-Federalists, they really didn't want to vote for the Constitution because they thought it consolidated too much power in a central government. They were worried about a king. They were worried about a king violating the individual rights of its members and redoing the Revolutionary War. So they were given a promise by the Federalists that upon ratification of the Constitution, the first thing that Congress would do would be to pass a Bill of Rights. And these rights would contain all of the natural fundamental laws that the Anti-Federalists felt that people had and should not be violated or taken away from by the federal government. And so here we are. First Amendment talks about freedom of speech, freedom of religion, freedom of press, freedom of assembly, freedom of petition. So freedom of religion, there is no state-sponsored religion. You can practice any religion you want in the United States. You can even conduct religious ceremonies that seem kooky to the rest of us, but you're not allowed to just break the law and claim that as part of your religion. So if your religion believes in human sacrifice, you're not allowed to, slice open people's chests and rip out their hearts and drink the blood and stuff like that. And when you're arrested, be like, oh, it's part of my religion, right? You can't just violate other ordinary laws that apply to everybody. It also, as part of the state sponsor one, this, here at Carmel, it sucks for us because it means that students, have to pay tuition to come to Carmel, as opposed to, free education, like students get to enjoy in the Chicago public school system. And quite the education they're receiving. Duck. Speech. You get to say whatever you want, and the government can't come after you. So I just trashed the CPS. The government can't come after me for that. There are exceptions. You can't shout fire in a theater, bomb on a plane, stuff like that. You can't basically say something that's going to create an immediate danger, physical danger to individual lives surrounding you. Freedom of the press. So the press can investigate stories and basically say also whatever they want under the freedom of speech. Freedom of assembly. You're allowed, as long as you're not violating other laws, to get a group of people and be pissed about something in America, and then you can complain to federal officials in the form of a petition, where you can get, several thousand people sign something that you're angry about and send it to the White House, and it'll of course be promptly ignored, but you have the right to do that. Second Amendment, the right to bear arms. This was very controversial up until a few years ago. And the controversy was because the actual text of the Second Amendment says, in order to form a well-regulated militia, the right of the people to keep and bear arms shall not be infringed. So it's kind of some dense language, and so the anti-gun people said that individuals did not have the right to possess and carry firearms. It just meant that their state militia got to do that. And the pro-gun people said, no, that's BS. It says the people, and the people is individuals, not the states. And the Supreme Court sided with the pro-gun people. So currently, as long as you are an adult and not a convict or mentally deranged, you are allowed to own and carry, if you file the appropriate fees and training, a firearm almost of your choice. The Supreme Court said that you can't walk around with a bazooka or machine guns and stuff like that, but the more typical types of guns you're allowed to have. Quartering of troops, Third Amendment. This was such a big deal. Remember the quartering acts during the colonial era? The Americans hated that so much that they didn't want American soldiers to be able to quarter in civilian houses against their will. Right? I guess if you wanted to, you could let a Marine live in your house rent-free or with rent, and you would probably be happy. But you can't be forced to by the government. Fourth Amendment, this is a big one for criminal attorneys and the criminal justice system. Unreasonable searches and seizures and probable cause for a warrant. What this means is the government can't just knock on your door and start searching your apartment, your house, in some cases even your car, depending on the plain view doctrine, which you don't need to know for this. And they can't just take your stuff, and they can't, they have to have a warrant to do this, and in order to get a warrant, they have to provide a judge with some small amount of evidence that makes it more likely than not that something shady is going on in your house or apartment. Fifth Amendment, again, this deals with judicial branch type stuff. Double jeopardy. You can't be tried to conclusion for the same case twice. So if a jury acquits you, then the prosecution can't try again. However, if it's a hung jury, that basically means we give up. We can't come to a decision, then the prosecution can bring another case against you. There's all this nonsense about the movie Double Jeopardy. That's not good law, so don't even listen to that. You can't be forced to testify against yourself. So this is why you almost never ever see a defendant take the stand. Free legal advice to you: don't ever take the stand in your own defense if you're a defendant. You cannot be deprived of life, liberty, or property without due process of law, meaning the federal government can't kill you, can't lock you up, or can't confiscate your property without due process of law, which that means is they have to give you a trial first. So if you are in favor of capital punishment, or really even if you're against capital punishment, all you have to do is read this in the negative, and you can see that it is constitutional to take away your life. They just have to give you due process before they can do so. Amendment number 6, again with the judicial branch. A lot of these deal with the rights of the accused, you can see. A speedy public trial, so they can't arrest you, throw you in jail, and say, your trial is scheduled for June 1st, 2045. Enjoy. Impartial jury, meaning they can't just stack the deck with a bunch of cops or other jurors who are perhaps inclined to be against you. Juries are supposed to be neutral, and they conduct a questioning called voir dire to try and determine if a juror and a jury panel is impartial. You have the right to be informed of a crime, so you're very quickly, after you're arrested, you're brought before a court, a judge, where they actually tell you the charges that you're being brought up on. You have the power to, or you have the right, I should say, to confront witnesses, which means you have the right to cross-examine a witness who is claiming that you did something. This can be a tricky situation in cases like rape, where the rapist has the right to cross-examine the rape victim, because really the best evidence against the rapist is oftentimes the rape victim herself or himself. And so that can be a very difficult situation. I've seen courts that try and put them in different rooms, and they use like a court version of Skype. But even that, then the defense usually claims that that's just like implying guilt on the rape. It's all this stuff. It gets very nasty. You're guaranteed counsel. So you've heard the Miranda rights, right? If you can't afford an attorney, one will be provided for you. This is a fairly modern development. The Constitution says that you are allowed to have an attorney. In other words, they can't prevent you from having an attorney. But up until fairly recent times, you weren't given a free attorney. You had to pay for one. And if you were too poor, then it's time to read up a few law books because you're on your own. But they changed that in the 20th century, and now if you're too poor for an attorney, you will get a court-appointed attorney, probably a public defender, and they tend to be the worst attorneys on earth. They tend to be young. They tend to be attorneys that barely pass the bar exam towards the bottom of their law school class. They give a portfolio of hundreds, if not thousands, of cases, and you'll probably meet your attorney on the morning of the trial date itself. The Seventh Amendment says that you have a right to trial by jury. You don't have to have one. You could just have a judge decide your case. But again, some more free legal advice. If you are a defendant, especially if you are guilty, you always want to have a jury because you want 12 idiots to decide your case as opposed to a learned judge. You want to be able to have the means and the opportunity to fool these 12 idiots as to why that you should walk free. Eighth Amendment, cruel and unusual punishment. The government is not allowed to torture you, so they can't, if they want to get a confession out of you, or if they want to, punish you, they can't, stick you in the stocks anymore, or, an Iron Maiden, or various other torture devices. And this has become an issue lately with waterboarding. And some of the other stuff that happened at Abu Ghraib prison and a few other places. 9. The Constitution does not deny rights it does not discuss. So this is like a catch-all. So just because it isn't listed in the Bill of Rights doesn't mean that you don't have that right. This has been made, abortion, right? Under Roe versus Wade, a woman has the constitutional right to an abortion. And what they do is they kind of lump together a bunch of rights. The First Amendment, the Fourth Amendment, the Fifth Amendment even, and the Ninth Amendment. And they say under the penumbra is the word they use of all of these constitutional amendments that you have a constitutional right to an abortion, despite the fact that the word abortion is nowhere in the Constitution. I think the best argument is really the Ninth Amendment, right? It's basically right there. It says just because abortion is not listed in the Constitution doesn't mean that you can't have one, right? They kind of leave it up to the courts to decide. 10. Powers not delegated are reserved by the states. So in the Constitution, if the federal government or a branch of the federal government is not given a power, then the remaining powers that are not given are given to the states. This brings up federalism and why the states are able to have all of these concurrent overlapping powers of the federal government. 13th Amendment, 14th Amendment, 15th Amendment. These are called the Civil War Amendments because, hint, hint, they were passed in the aftermath of the Civil War. 13th Amendment says that slavery is finally abolished. 14th Amendment reads very similar to the 5th Amendment. No state can deprive a person of life, liberty, or property without due process of law and cannot deny equal protection under the laws. The reason why they have this amendment, which looks so similar to the 5th Amendment, is because the 5th Amendment prohibited the federal government from doing these actions, but the states in theory could. The 14th Amendment says no states can do all of these actions. So there's your difference. What's been interesting, and I guess you'll read about it next year in AP Government, is that the 14th Amendment has been used to incorporate the other amendments to also apply to the states. Because if you read it this way, then the First Amendment, freedom of speech, well, I guess a state could deny freedom of speech then, because the First Amendment would only apply to the federal government, right? Second Amendment, the right to bear arms, well, a place like Washington, D.C. or New York could deny a person the right to own a gun because the Second Amendment only applied to the federal government. Well, the 14th Amendment, the Equal Protection Clause, has basically been used over the last 200 years to slowly, over time, incorporate all of those Bill of Rights protections on a case-by-case basis to also applying to the states. So even though the 14th Amendment looks like the 5th Amendment, the 14th Amendment basically smooshes together all of the previous 10 amendments, or the first 10 amendments, to also apply to the states. And that's called the incorporation doctrine. 15th, the right to vote cannot be denied on the basis of race. So African Americans were able to receive the right to vote on account of this amendment. Notice how there was nothing regarding women, though, and so women could not vote still. 16th Amendment, this is a more progressive era, so early 20th century amendment now. Income taxes. The federal government has the right to take money out of your paycheck, right, to tax your income. And they needed an amendment to do this because, remember, the Fifth Amendment said they cannot take away your property without due process. So without the income tax amendment, they would have to give you a trial each and every time that they took money out of your paycheck. They're not going to do that, so they have to modify the Constitution to let them do that, and so they passed the 16th Amendment. 17th Amendment, also another progressive era amendment. Senators are now elected by the popular vote as opposed to by the state legislators. 18th Amendment, also another progressive era amendment. Liquor is abolished, right? So the consumption, sale, and manufacture of alcoholic beverages, basically during the 1920s, during the gangster era of Chicago, that's prohibition. That alcohol was prohibited. Exceptions, of course, for religious ceremonies, such as the Catholic Church. 19th Amendment. Women get the right to vote. That's another progressive era amendment. It's called suffrage, and they've been able to vote since, I think it's 1920 or so. 21st Amendment, which was passed, I believe, in 1934, approximately 14 or 15 years after the 18th Amendment, states that prohibition is abolished. Notice how I've skipped some amendments. The reason why I skipped those amendments, they're not on the Constitution test, and I'm bored with them, so we don't talk about them. But according to the 21st Amendment, as long as you're 21 or 18 in some instances with your parents, Drinking booze is no longer illegal. 22nd Amendment was passed in the aftermath of FDR presidential term limits. So currently, presidents can only serve 2 terms, not forever, like FDR tried to do. 26th Amendment was passed in the aftermath of the Vietnam War, where it lowered the voting age from 21 to 18, and the logic goes, if you are old enough to be drafted against your will and sent across the world to fight and possibly die for your country, you should be allowed to vote for the individuals that make those decisions on your behalf. 27th Amendment, which was actually submitted as part of the original Bill of Rights, so it could have possibly been like Amendment number 8 or 9 or something like that. It actually wasn't ratified until the early 1990s, and it deals with congressional pay increases. Because prior to this amendment passing, Congress would vote themselves raises all the time, and they would be effective immediately. Nowadays, they still get to vote themselves a raise, but that raise doesn't go into effect until the next congressional takes office after the winter recess. So there's a chance that they could vote for it, but then not get to experience it because they lost a re-election and the new guy comes in and gets to enjoy the fruits of your labor. That's it. That's amendments. Congratulations. You now know everything you need to know about American government to be an educated American.